This has been the week for sanctions. And I don't mean your usual piddling $2,000, $3,000, $5,000 in sanctions. We're talking about sanctions in significant six figures. And furthermore, these two sanction opinions came from major active jurisdictions, Delaware and New York City. The first comes from bankruptcy judge John Dorsey in Delaware. Judge Dorsey has been on the bench about a year now, and I suspect he was a little queasy in the boots before he did what he did, but I'm pretty sure from reading his opinion, he felt as though he had no alternative. What it amounts to is that Judge Dorsey caught the same law firm for failing to disclose fee-sharing arrangements not once, but twice. The first time around, he sanctioned the law firm for $55,000. The second time, he was not so forgiving. The second time around, the second fee sharing that was not disclosed, he not only disqualified the law firm from continuing to represent the debtor as a special counsel, he also ordered the firm to disgorge all of the compensation that it has or will receive, and that is probably several $100,000. Well, the next judge to step to the plate was none other than bankruptcy judge Martin Glenn in New York City. This was a different kind of a situation, not a non-disclosure. Rather, he was dealing with the servicer of student loans who for 4 or 5 years had ignored his orders. For instance, an order discharging student loans. But the student loan servicer had gone ahead willy-nilly and had tried to collect those discharged student loans. Well, after these multiple instances of failing to appear in court or to abide by his orders, Judge Glenn was fed up. He awarded, get this, about $380,000 in sanctions against the student loan servicer. Now, Judge Glenn is a pretty smart man. He's been around the block a few times, and he knew that if he gave the $380,000 all to the debtor, it would probably, as sure as God made little green apples, get reversed on appeal, because that kind of punitive damages was really wholly unrelated to the damages that the debtor has suffered. So here's what he did. He gave $24,000 in damages to the debtor, but for the rest of it, more than $350,000, he directed the student loan servicer to reimburse the federal government Department of Education, which was the owner of the loan. That $350,000 represented full payment to the government for the student loans that he had discharged several years earlier. Well, what does all of this mean? It means, I suppose, pretty clearly, don't mess with bankruptcy judges, because if you do, it can really get or make a very deep hole in your pocket. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something important in bankruptcy, or if not important, then something very interesting, just like these two cases. Thank you and good day.